Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be landlords forced to jump through hoops in order to perform an eviction. Well, hello everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. The song was another artificial intelligence song that I created called The Tenant from Hell. I will have it, if you're watching this after this broadcast, I will have it at the end of the show if you did want to catch it again. The format of our show is that I start with an opening topic, and then for those people in the Zoom meeting, we'll open it up to questions and answers. If you are in the Zoom meeting, please electronically raise your hand now so you'll have the best chance that I will get to you before the show concludes. And if you are in the YouTube, please subscribe to my channel and hit that like button because it really does help me. So let's talk about the topic of the day. And the topic of the day is landlords forced to jump through hoops to perform an eviction. That's right. Landlords are forced to jump through hoops to perform an eviction. The fairness, and law is supposed to be fair. Fairness is thrown out the window when you're dealing with landlord-tenant law. It has nothing to do with fairness. It has everything to do with procedural requirements. So fairly, a tenant who hasn't paid rent in 6 months without any excuse should be evicted. Fairly, a tenant who has created a nuisance, bothering other tenants or damaging the property, that person should be evicted. But none of this, at least in the state of California, has to do with fairness. It has to do with procedural requirements. These procedural requirements are so varied, so intricate, that it is almost impossible to navigate the system. And we're going to go over some of those main points in this opening topic. But again, if the law deals with the concept of fairness, there's nothing fair for a landlord in this situation, nothing fair. Now, let's talk about the rules and regulations that landlords have to navigate. You would think it would just be one set of rules, but of course, it's not even one set of rules. You have to deal with federal rules, you have to deal with state rules, and you have to deal with local rules. This is an impossible situation for landlords to go through when legitimately and fairly that tenant needs to be evicted. Let's go over some of them. I want to first start with the federal rules. And that is, if you have a Section 8 tenant in your building, just one, or you have a loan on that building that's federally backed, like a Fannie Mae or a Freddie Mac loan, the normal notice to pay rent or quit cannot be used. You have to use a form that's called a 3-day notice to pay or 30-day notice to quit. In other words, if the tenant doesn't pay in 3 days, you still have to wait 30 days before you can file the lawsuit because the tenant now has, under federal rules, 30 days to vacate. Now, again, this is for any property in the state of California where you have only one tenant in the building that's a Section 8, you've got to serve that notice for everyone in the building. Or if you have a federally backed loan like Freddie Mae or Fannie Mac. Okay? Now, under state laws, you have to have specific things in that 3-day notice to pay rent. If you don't, again, fairness has nothing to do with this. They will make you lose your eviction case because you have not complied with all the regulations. So what needs to go into a 3-day notice in addition to the amount of rent that's currently due? Well, you have to have in that 3-day notice the name, address, and telephone number of the person who to pay the rent to. Now, if your building is in an LLC or a corporation, you can say pay it to that corporation, but deliver the rent check or the payment to that individual. So you have to have an individual's name. He has to have his phone number and an address where he can deliver it. It can be a P.O. box, but you still have to have that name. You also have to have in that notice to pay rent or quit, you have to have times when payment can be made. So you can say Monday through Saturday, 9 to 5. But if those are not there, ladies and gentlemen, then you will lose your eviction case. Also, and this is another item that must be contained in the notice under state law, and that is you must have a phrase that says, when counting days, those 3 days, you must exclude Saturdays, Sundays, and judicial holidays. If that is not in the notice, you lose the case, even though you gave the tenant more time to pay the rent. It's irrelevant. Those magic words have to be in the notice. By the way, these notices are all on my website at evict123.com in the free form section. Feel free to use them. It will have the proper state language in them. Also, under statewide rent control, if your property is subject to that, they have another curious item. If you're serving a notice to perform or quit for a violation of a rental agreement, for example, they brought in extra people, a pet, or they made alterations to the premises, you have to serve them with a 3-day notice to perform or quit. In other words, 3 days to get rid of the pet or to get rid of the unauthorized person. But under state law, and really, who's going to know this? After that notice expires, you'd think you'd be able to file your own unlawful detainer action at that point. But no, under the state law, you have to then serve an additional 3-day notice to quit. After that notice expires, now you have the right to bring forth an eviction. So these laws regarding both the federal statutes and statewide statutes are pretty difficult to comprehend and to navigate. But now we get to the worst, and the worst is local rules. Local rules are designed merely for landlords to fail. That's it. That's the only reason why they exist. Has nothing to do with fairness. Remember, the law is fair? Nope, not when it comes to landlords and tenants. It's not fair whatsoever. So let's take, for example, the city of Los Angeles. They have a plethora of requirements and regulations. If you fail to comply with any of these, you lose your eviction case. That says it right in their statute. Failing to comply with any part of this statute will result in a defense to an unlawful detainer. Makes no difference that the tenant shot up the rotunda with a gun. It would make no difference. You would lose your case because you didn't comply with each and every rule. So what are these rules? Well, number one, all rental units, and I mean all rental units in the city of Los Angeles now have to be registered. Not just those units that under the rent stabilization ordinance, but every unit, brand new units, single family homes, condos, I don't care. They all have to be registered now. You have to register it. You have to register it completely. They do require that you fill out forms as to exactly what the unit numbers are and who the tenants are and what their rent is per month. Because if you don't fill it out and pay the fees, you're not going to get something called a registration certificate. And if you don't have that registration certificate, you can't serve a notice to terminate the tenancy. You have to have that registration certificate. And that registration certificate, which you get every year in the city of Los Angeles, for example, this year it would say 2025, if you have the current one, that registration certificate has to be sent to your tenants. You cannot serve a termination notice on your tenant unless your unit is both properly registered and that registration certificate was sent to your tenant. Now, there is a website that you can go to that will allow you to see if your unit is properly registered. So I'm going to share my screen right now, and I'm going to show you that website. And there it is. I'm going to tell you what the web address is, the website, but it will be in the show notes, but you can kind of see it there. And it is LAHD, standing for Los Angeles Housing Department, .service-now.com/EFS. By going to that website, actually .PLU is really what it should have been. By going to that website, you'll be able to check to see if your units are registered online. Now, the other thing that you have to do, which is actually what this page is up for, is you have to also upload your termination notice to the city of Los Angeles within 3 days. Again, that website ends with /EFS, and I will have that in the show notes. You have to set up an account, and then every time you serve a notice to pay, rent, or quit, or a 60-day notice, or a notice to perform or quit, you have to go to this website and upload that within 3 days of the service of that notice. If you don't do that, ladies and gentlemen, your case will be lost. Now, why does the city of Los Angeles need to see the termination notice that you served? What reason would they have to do that? Well, logic would say, well, they want to check these notices out to see if, in fact, the landlord is serving a proper notice so that they can call the tenant and protect the tenant. That would seem logical if you're the city. But you see, I've been in contact with members of the Los Angeles Housing Department, and the city of Los Angeles does not in any way review these notices. Don't even look at it. Well, if they're not looking at the notice, why are they forcing landlords to upload every termination notice that they receive to the city? Well, it's obvious, ladies and gentlemen. It's one reason and one reason only. And that is so that tenants' attorneys will see whether in fact you uploaded it to the city. And if you didn't upload it, then you're going to lose your case. It's just a trick, a trap. It's a regulation that they're hoping landlords don't follow. And if they don't follow those regulations, you will lose your case. The city is not looking at these notices. What is the point in having these notices sent to the city if the city isn't reviewing these notices? Let's move on. The city of Los Angeles also requires that you post notices on your property in a conspicuous spot. And I don't care if, in fact, it's a single family home or not. These notices all must be posted. By the way, these notices are all on my website at evict123.com, and they're in the free form section. So let's take a look at the first notice, which I'm going to share my screen right now. And you're going to see this is City of Los Angeles Renters Protection Notice. This needs to be posted on every single residential property. I don't care that you've got this single family home in Brentwood leased for $50,000. This has to be posted in a conspicuous spot on the property. Now, let's send this in here. If you have RSO properties, then in addition to the properties that are under JCO, the Just Cause Ordinance, you're going to need to have this notice posted in addition. So both notices have to be posted. Both notices are on my website. Okay? Now, let's move on. What's another trick that the city of Los Angeles pulls so that landlords will lose their eviction case? And that deals with the concept of interest on security deposits. Now, I have talked about this before, and I want to share my screen on that if I can do this. There we go. Every year, if you take a security deposit, now this is only for RSO properties, then you need to pay interest on security deposits every single year. If you haven't done it, then go to this chart, which is on my website. We're going to show you that right now. And it's going to go back to the year 1990 to the year 2000. If you haven't sent your check to the tenant on interest on a security deposit that you've taken, do that now. Just send them a check. It's not going to cost that much, at the most $20. But look at this chart. This chart is on my website. It's not in the freeform section. It's in the legal issues section. But again, if you pause this video, or if you go to my YouTube channel after this is edited, you'll be able to see this. But again, that is a trick. We had a situation where another attorney who used to be with my firm did this whole jury trial, lasted for, 6 days. And it turned out that they did not pay interest on security deposits. If you don't pay interest on security deposits, you will lose your case. Ladies and gentlemen, you will lose your case because you didn't pay that. Even though the tenant owed 5 months worth of rent and the interest would only equal $4. Remember, this has nothing to do with fairness. It has everything to do with making it so landlords cannot go forward and win an eviction case. Now, I have in my on my rental agreement, I have a phrase in my rental agreement that just in case you haven't done it, that we can still potentially win. And that's if you go to my website, evict123.com, and go to the free form section and look at my lease, I have this phrase in my rental agreement. And it states, if the premises are subject to a law which requires the landlord to pay interest on security deposit, then an additional fee will be owed by the tenant to the landlord representing a management fee. This fee shall be equal to a 4% of the security deposit or the amount of interest required to be paid by the landlord, whichever is less. This fee is due on a yearly basis. So I have that in my rental agreement just in case the landlord didn't serve it. But again, let's not rely on this because it hasn't actually been tested. But if you can make it so that if you can, if right now you know you have an RSO property, you didn't pay interest on the security deposit, please, whatever you do, then you have to um, pay that interest right now. Do not delay. Okay? Now, um, another trick that the city of Los Angeles does, and also deals with the um, LA County, unincorporated areas of LA County, you have something called the threshold. The threshold, ladies and gentlemen. And what is the threshold? That threshold means that you cannot serve a 3-day notice unless the amount in total exceeds the threshold. Now, again, this is just for the city of Los Angeles and unincorporated areas of LA County. So you have to be above the threshold. So what's the threshold? For a single, it's $1,856. So if I have, for example, a single unit, no bedrooms, and the rent is $1,800, and they don't pay me rent for the month of March, I can't serve a 3-day notice because I'm below the threshold. I would have to wait till April, then they'll owe me a total of 2 months rent, $3,600, and then I'm above the threshold. For a one bedroom, it's $2,081. A two bedroom, $2,625. A three bedroom, $3,335. And lastly, for a four bedroom, $3,698. Again, you can't serve a 3-day notice unless you're above the threshold, which means that tenants legitimately could just pay their rent 25 days late every single month if they're below the threshold. So if you are going to lease out a unit, make sure, and the city council, which and unincorporated areas of LA County, I guess, are trying to encourage, affordable rents. But based on this formula, you'd have to be out of your mind to lease out your building, lease out that unit if it wasn't way above the threshold. So they've just created higher rents for vacant units. So again, make sure you're way above the threshold so you don't get into a situation if you do have to serve a 3-day notice. Now, in the city of LA and unincorporated area of LA County, in their notice to pay rent or quit, you also have to have the number of bedrooms. You don't have the number of bedrooms, even though you're above the threshold, you lose your case. And it gets even worse for unincorporated areas of LA County. Not only do you have to have the number of bedrooms, but you have to state what the fair market threshold is. So, for example, a one bedroom is the fair market value is $2,081. You have to have that contained in the notice or you will lose your case. Again, having nothing to do with fair amounts, fairness in these types of cases. Other cities like Pasadena, they just throw in special language that has to be in your 3-day notice to pay rent or quit. If you don't have that in your notices, you will lose your case. I want to show you, and I've shown you this before, and this is on my website. I'm going to share the screen one last time. And I want to show you all the different municipalities and what their requirements are. Like in Culver City, I have to send a copy of the notice to the Culver City Housing Department within 5 days. And you can see all these cities here from Inglewood, Santa Monica, Santa Ana, West Hollywood. These are all specific local requirements that if you don't comply with them, then your case is doomed. Who's going to know this? Who's going to know this? No one. The system is designed for landlords to lose their case. And again, the concept of fairness and justice is thrown out the windows, everybody. It's just thrown out the windows because their job is to make you lose your eviction case. And that's why you do need to use the services of an attorney to go forward with these cases because you will definitely lose your case. We just took in another case where somebody wanted us to substitute into an existing case. And of course, as soon as I saw the case, we knew that in fact that the case was doomed and we had to advise the heartbroken client that we needed to dismiss this case and start it over again. Okay, that concludes my discussion on landlords forced to jump through hoops to perform an eviction. We're now going to open it up to questions and answers, and we know the rules, and that is this broadcast is for informational purposes only. It is not a substitute for legal advice. Electronically, raise your hand if you're in the Zoom meeting, and I will be happy to call on you. Again, if you're watching on YouTube, please hit the like button and subscribe to my channel because it does really help me. And this program is for general questions only. If you do have a case with my office, no problem. Call the office. We take hundreds of phone calls per day, and we're happy to answer any questions on your existing case. In the Zoom meeting here, please just limit it to general questions only. And last but not least, if you are talking to me, leave your camera on because it makes it much more enjoyable for me and the audience. And with that, we're going to open it up to our first person, which is Dana Lungs. I'm not pronouncing that right, but I think you know who I am. Please unmute yourself.
Hi, Dennis.
Hello.
Actually, my name is Maribel. I'm at my daughter, so I'm using her laptop. So, my question is a follow-up to last week's question. So I went ahead and ordered an inspection for the property in Gardena, a quadruplex that I was intend to purchase. So during the inspection, I noticed that two of the units have pets, but I was reading their lease agreement, which incidentally the seller was using your form. They didn't look like they had signed a pet agreement. So is the ordinance for the pet ordinance, is that for RSO only because Gardena is not under RSO?
Okay,
Or
there is no pet ordinance that exists. The state legislature was contemplating starting it, but it never passed. So if the rental agreement prohibits pets, you would have the right to serve that tenant with a notice to perform or quit. But since you're in Gardena, the city of Gardena, you're under statewide rent control. So you then would be forced after that 3-day notice to serve an additional 3-day notice to quit. Now, what I would do is I would ask the current owner, hey, did you know about these pets? Did you authorize them? Because even though the rental agreement says no pets and you can't change this agreement without having something in writing, many judges are going to be very loose on that issue. So I would talk to the current owner, the seller, and say, hey, did you know about these pets? Did you authorize them? Or had you in the past told them, hey, this is not a proper thing and to get rid of it? So that's how I would handle that.
okay, all right. Thank you, Dennis.
You're very welcome. And now we're moving on to Mike Darian. I'm going to ask you to unmute yourself.
Hi, this is actually Rena. Hi, Dennis.
Hello, Rena.
Hi. This property is in Glendale. It's a triplex, and the tenant brought in an extra person. When I found out, I sent him a 3-day notice saying it wasn't part of the lease. And he said, yes, this person, because of the fires, she lost her home and she's now here. I know that's not the case because her car was there way before the fires, but that's his story. So what are the rules on that now? Is there a moratorium on increasing the rent because of a new person in the unit?
First of all, you're under how many units on the property?
3.
Okay. I don't think you're under Glendale statute because I think it's more than 3, though I'd have to check that out. Do you know if you're under the Glendale rent control ordinance?
Yes.
Okay, so then it's 3 or more. Okay. So if you're under the Glendale rent control ordinance, you're not allowed to increase the rent even if an extra person moves in. You have the right to serve a notice to perform or quit, giving that tenant 3 days to get the stranger off the property. There is a law that states that you can't evict the tenant if the tenant brought in somebody who was a victim of the fire. But as you're saying, that car was there way before, so she's not going to be able to prove that. And I think you can go forward with that lawsuit if that's what you'd like to do.
Yeah, but if I wanted to just increase the rent,
I
could
don't
you
think
say?
Glendale has a provision for increasing rent for an extra
I
person
see.
moving in. The city of Los Angeles says 10%, but Glendale doesn't have that as a provision.
Okay, but I could just go on and his rent increase is due in June. I can just give him a notice for that.
Absolutely, and you should. Yeah,
Okay.
as a general rule, everybody listening to this, if you can legally raise rents, raise rents. Doesn't matter what the value of the property is. Raise rents to market level because we don't know what type of new rent control ordinance will be around to hurt us. So make sure, and if your rents are at market level, then they really can't hurt you too much. And with that, we're going to move on to Lilia. Lilia, how are you today on a Saturday?
Hi, Dennis. Can you hear me?
I can.
Oh, perfect. Thank you. And I don't know where to put my cap. There you go. Hi, Dennis. Thank you for taking my call. So this is a single family residence in Chula Vista. And we gave a contract for 3 years. And I would like to know if we can end the contract or lease at the end of the 3 years.
Okay, first of all, Chula Vista is in San Diego County.
Correct.
Chula Vista does not have rent control, though I don't handle that area. However, is this a single family home or is it
Single family home.
only one house on the lot?
Correct.
Okay, did you have a phrase in your contract that states this property is exempt from statewide rent control?
I don't remember if we check mark that.
If you did check mark that, then you can tell the tenant by way of a simple informal letter that your lease is up as of this date. It's not going to be renewed, and we expect you to vacate the premises. Unfortunately, if that box wasn't checked, then she becomes a protected tenant under rent control, and you have to have under statewide rent control, and you have to have a specific reason to evict.
Oh, okay.
Go check your rental agreement.
Okay, thank you. And the second question is, now that you're mentioning, so for other cities, counties, if they bring another person into the property, we cannot raise rent for any reason. We just have to allow for that extra person or evict them.
You have to evict them unless there's a local statute that says that you can ask for more money if an additional person is brought into the unit. I know under statewide rent control, they don't have that provision.
Okay. How can I find out that? Do I have to call the city?
Well, Chula Vista doesn't have
No,
rent control.
No, this is in Anaheim.
In Anaheim?
Yes.
I don't believe Anaheim has that, but you can call the city of Anaheim and ask them.
Thank you. Thank you, Dennis.
Moving along to David. How are you, sir?
Thank you, Dennis. I sincerely thank you for all these informative podcasts that you're offering. My question is very simple. I'm talking about Senate Bill 2747. Does this, as you know, it becomes effective April 1st. Does it allow us to also report negative credit reports from these tenants that are not paying on time?
So what David's talking about is that there's a new law that becomes effective as of April 1st, which states that you have to offer in writing a contract to the tenant that states, uh, if you want to pay me up to $10 or what it actually costs, every time that you pay your rent on time, I'm going to report that to the credit agency, which will assist in making your credit score go up. And that contract has to either be contained in the rental agreement or given to them at the time of the inception of the tenancy starting April 1, or for existing tenants, you have to offer them in writing that contract. I just recently put that phrase in my contract at the end of my residential rental agreement so that if you are doing that with new tenants, you can offer that to them. Now, that doesn't answer your question. Your question is, well, I know I'm supposed to report positive rent payments. Can I report negative rent payments? And the answer to that is, I think you're allowed to do so, but there has to be a phrase in your contract that states that if you do not perform timely, then I can report you. Also, if you don't have it in your contract, you have to send them a note 30 days before reporting it. So that phrase is in my new rental agreement. In fact, that just got added in on Friday, uh, yesterday, so that that phrase is there. So again, if you want to report negative payments to a credit agency, so to make sure that the whole world knows that this is not a good tenant to take, then you either have to have that information contained in your rental agreement, which states, if you do not pay your rent on time or fulfill the obligations of this contract, I have the right to report you to a credit institution. If it's not in your rental agreement, then you need to send them that note and state at least 30 days before you're going to report it. So you could do it now, and then anytime in the future, you could then report it. So hopefully, David, that answers your question. And I will take that as a yes. Thank you so much. And we're going to move on to a number 025994. Unmute yourself, please. That's what it says your name is, 025994. If you're there, please unmute yourself.
Is that me?
That is you, young sir.
Oh my gosh. First of all, I'm sorry I don't have the camera on. I haven't figured that out. But real quick, one question and another question about your form. There's something missing in your forms. In the rental application screening, can I require only applicants with local rental history verifications?
I don't think so, because then you're discriminating on based on where they live, and I don't think that's a rational basis of discrimination. So in other words, if a person has great credit but just moved from Flagstaff, Arizona, can you deny them? I would think that wouldn't be proper.
The problem is that how can you know who you're talking to in Flagstaff, in Arizona?
Well, how do you know who you're talking to in Culver City if you
Oh,
call?
I knock on the doors, and in fact, not only do I knock on the doors, but I talk to the adjoining tenants to see what type of person.
Well, you can always call somebody in Flagstaff, and I don't know how many current landlords are going to want you to knock on their door and say, "Hey, I'm thinking of taking this guy." I don't think many people are going to like that. But I'll tell you the better way to do it, and I've talked about this in previous shows,
Okay.
and that is ask the tenant to show you the last 6 months' rent payments that he made to that landlord. You want to see proof of payments. If he's paying his rent to that landlord, then you know he's a good credit risk.
Okay. And just the second thing was under AB 602, that's these squatter things. You're supposed to be able to go to the local police station, etc. Previously, you have said that you have the 602 letter as well as a no trespass sign to put on the property. I couldn't find that on your site.
I don't have a no trespass sign, but I do have the trespass that needs to get filed with the local police department, and that's in the legal issues section. So go to
Okay.
legal issues, scroll down, and you will see it, sir.
Great. Thank you so much.
Have a great day. Moving on to Tatiana. Say hello.
Hello, can you hear me?
Perfectly. Look at you. Uh-oh, we lost you. You might need to unmute yourself again, please. Oh, you know what, darling? You're having a problem with your mic. And I think you did this before. I could be wrong. So what we're going to do is we're going to move on and I'm going to come back to you. So we're going to move on to Richard. I'm going to ask you to unmute yourself, Richard.
Yes, Dennis, this is Richard. Good afternoon.
Hi.
Hey, I've got a question. I'm trying to enforce a term of tenancy on a commercial tenant in Los Angeles, tenant to a market. And the tenant is refusing to insure the premises, which is on the lease agreement. I'm getting some quotes for insurance, and my idea is to serve them a 30-day notice of rent increase, dividing the amount of the insurance into 12 installments to cover the cost of insurance. I
Is
don't
your
want,
tenant on a month-to-month tenancy currently?
yes,
Well, then absolutely. You don't have to even keep it like that. If the guy doesn't want to get insurance and you've asked him, then just raise his rent even more than what the insurance policy, because
right,
under a commercial lease that's month to month, you have the right to raise the rent to whatever you like. There's no limitations. So I would even go more than the price because, all he had to do was get insurance and now he's forcing you to get the insurance. So I would even charge him even more.
got it. On that note, if later the tenant refuses to pay the increase, because usually it's a $100 increase a year I've been raising them. Let's say if I choose to raise them $400 and he refuses to pay that amount. If I decide to accumulate a debt owed, let's say after 2 years, he's accumulated $5,000 in rent owed that I've decided to discount and keep him on as a tenant. If 2 years after, if I decide to sell the building, do I have recourse in suing him for that back rent?
Well, I think you can sue him for the back rent because it is a charge. You raised the rent and he didn't pay it. I don't think a court would state that you, quote, waived it. You might want to send him a confirming letter saying, hey, you are only paying, you're shorting my rent every month by $100. And
Right,
I would write
balance,
a
show him
few
what the
letters like,
balance is.
I'm sorry, what?
Yeah, I would show him what the balance is.
Yeah,
each year
on the
that-
ledger card, sure.
Right. And okay. And I guess if I did list the property for sale, you know how they ask you what your current rents are. I would state what the current rent is with that increase to that tenant.
That is accurate. Now, another thing that you could do is you could take one of those knives behind you and you could stick it to the guy.
Right.
We talked about your knife collection last time.
Right. Second question. Not sure if this is up your alley, but in a joint tenancy, if property is owned by two people and only one lives on the premises, what powers does the tenant, or not the tenant, but the joint tenant that has 50% value does not live on the property? What powers does that half owner have to that property?
Well, I mean, you have just as much power as any, whether you live there or not. You're the owner of the property. If you're, and I'm not sure where you're going with this, if you're saying, hey, you're living there, I want to get my contributive share, so you should at least be paying me whatever the rent value is, divide by two. Is that where you're going with this?
No, I guess I was just wondering if the I mean, obviously you need two signatures to borrow money or to sell the property. Can they force a sale of the property?
You could have a receiver appointed based on certain conditions, and then force a sale to the property, especially since the person in possession is getting the use of the property and the person not is on the shy side, so to speak, and yet you're paying your share of the property taxes. So that could be a forced sale.
Understood. Okay, well, thank you very much for that.
Thank you, Richard. We'll try again one more time, Tatiana. If you can do it, unmute yourself.
Can you hear me now?
I can.
Awesome.
Don't
I
touch
don't know what,
anything.
I'm not touching anything.
Okay.
Hands up here. So thank you again for all the information today. I have questions regarding an Airbnb in Kern County, just kind of seeing if there's any forms on your website that you can just kind of refer me to for language that I should add in the contract.
Well, if you're dealing with an Airbnb, then Airbnb takes care of all the contractual matters. In fact,
Okay.
you're getting your money from Airbnb, the tenant's paying their share to Airbnb. So, but you
Okay.
might want to check the local rules in Kern to see if they even allow for Airbnb. Many municipalities don't allow Airbnbs.
Okay, I just wanted to make sure if there's anything additional. And thank you again. And then, so my other question is more for a residential home here in La Mirada. It's in the LA County. It's a single family home. We're thinking about renting a room. Would we have to go through the same process, like registering the unit, I guess, or the room, or is it more of like it's just a roommate
Okay.
kind of situation?
You said it was in what city?
La Mirada.
Okay, La Mirada is an incorporated city and it doesn't have any kind of a rent control. So on that basis, you'd be fine. You don't need to do anything special.
Oh, okay, awesome. Thank you so much.
Thank you. I'm glad you hung in there. We are going to move on to Judy Leung. Say hello.
Hi, Dennis. How are you?
I am good, thank you. Nice to see you.
Okay. I was original have two questions for you. Actually, today on your seminar, I already learned to get the answer for my first question. The second question is since I'm the first time doing the eviction, actually my court date already set up for April the 7th.
Yeah, but remember, we don't talk about specific cases. If you
Oh,
phrase
okay.
it only as a general question, I'm happy to answer.
Okay, I can make a general question. So if I dismiss the original case, and I can right away jump on to this, to the, second suit?
Well, of course. I
Just
mean,
like
if
a
you have a
3 day.
procedural mistake in your action, and therefore it's not worth going to court and just losing it, you might as well dismiss it. The second you dismiss the case, you have the right to serve a new notice to the tenant and proceed forward with an eviction.
Okay, is that, the original was started like a 3 day notice. Now is, almost it is 3 months late.
Well, of course. I mean, when you serve the new notice, you're going to be serving it for the correct amount of rent that's due. So you'll also include all the rent owed through the month of March.
Okay, all right, thank you. Another question is, after it all went through, if the judgment for my advantage and all the expenses I accumulated during the lawsuit, are they all I can sue as tenant to pay for it, or I have to
Well,
take
all
care of
court
some of it?
costs are, if you're the prevailing party in a lawsuit, all court costs are the responsibility of the person who lost the case. With regard to attorney's fees, that's a whole nother issue. Attorney's fees are only granted if, number one, you have a paragraph in your rental agreement that authorizes attorney's fees, but many paragraphs in rental agreements limit the attorney's fees to $500 or $1,000. So you want to check your rental agreement, and it's always a good idea to have that in your contract where attorney's fees are limited, because if you do lose your case, the tenant's going to come after you, and if it's a jury trial or something to that effect for $20,000, if you win your case, yeah, you're going to get that same judgment, but it's going to be much more difficult for you to collect against a tenant versus a tenant collecting against a landlord. Anyway, thank you very much. We're going to move on to Daphne. What a pretty name.
Hi, Dennis. Nice to meet you. I've been following you for quite some time.
Should I be looking over my shoulder?
No.
Okay.
So, I'm a realtor and I'm having an issue right now regarding my parents' ADU. So based on everything you've disclosed to us here today, would all of these apply to the ADU or we have some leeway?
What city, please?
West LA, District 11.
Okay, and the ADU, I'm sure, was built after 1979.
Correct, that's a recent
And when
ADU.
and you say you're having a problem with the ADU, what's the problem? Is it non-payment of rent?
No, we don't have a payment right now. We're having a problem with all the rules and regulations, which LA Housing is enforcing. And my
Well, I mean,
concern,
obviously, in the city of Los Angeles, you now have to register those units that are subject to the just cause ordinance, which this ADU is. So you're gonna have to register that unit. You're
it's
gonna have to
been,
pay a fee,
we have,
the
past 2
$31
years,
and 5 cents.
correct.
Okay,
Yes.
so you have to send a copy of that registration to the tenant.
Okay.
And then have them sign a strong rental agreement and make sure that the tenant coming in, you've checked their credit every which way and asked for those, last 6 months of rent payments to their current landlord.
Tenant has been there since August 1st of 2024.
All right,
None
so
of this wasn't,
then they're already in. So then
Yeah.
you've complied if you've registered the unit, okay?
correct.
You don't have to pay interest on security deposits because that's only for those properties under RSO, the rent stabilization ordinance. You're under the JCO, which is the just
Correct.
cause ordinance. So,
Correct.
I mean, if you got no problems, then sit back and enjoy the rent coming in every month.
The problem is this, rent control is telling us only 8.9. You're telling us 10% for
I
rent
didn't say
increase.
10%, darling. Never said that. Your property is not subject to the LA rent control ordinance. It is subject to statewide rent control. Is your property built the ADU more than 15 years ago?
No, it was built about 6 years ago.
Okay, so then you're allowed to raise the rent to whatever you like. However, until the fire moratorium is over, we're recommending only 10%
Okay.
until
But-
July. Then you can raise it again as much as you like.
Okay. In the lease, I've placed in that they're supposed to provide a renter's insurance. They have never done it. And also, I wanted to
Well,
know.
let's do one at a time. Renter's
Yes.
insurance, if it's contained in your rental agreement,
Right.
you can't use that as a ground to evict the tenant because courts have determined that that's a trivial breach, even though I don't think it's trivial. However, the reason why you have those phrases in the rental agreement is if, in fact, the tenant's personal property is damaged through no fault of yours, or the tenant has to temporarily relocate because of maybe a flood or something like that, then you wouldn't have to pay for any relocation expenses. That's why you have that in there to say that you can't come after me because you were supposed to have insurance.
Based on these regulations and majority of people, to the best of my understanding, are elderly people, do you see any kind of a possibility of a class action lawsuit being brought against the city? Because this is somewhat of an elderly abuse. Not everybody have kids who are willing to attend to them. And who's justifying our time and our, attendance to
the
this when
city
we're
of
not
Los
making any
Angeles,
money? Yeah.
the city of Los Angeles doesn't care, and this is not proper for a class action lawsuit. There is a wonderful solution to all of this, and it is so damn simple. If you own property in the state of California, sell it and buy someplace else because this state is not property friendly, even though you are a wonderful broker. Daphne, thank you very much. We're moving on to, looks like, I would say, a Russian by the name of Sergerazov. I'm going to ask you to unmute yourself.
Yeah, it's me. Thank you.
How do you pronounce your name?
It's well, I go with Serge, but yeah, my name is Sergey. It's
And are you Russian?
I am, yeah. I am.
Okay, well, we typecasted you perfectly. Okay.
You did,
Anyway,
yeah.
tell Putin to settle this war, but what's your question?
Okay, yeah, I hear you. Well, okay, make it short. So this is Conda. This is Conda in Oak Park, and the the renter is a family with two little kids, husband and wife. Nice people, but he's very sloppy with rent. It's been 5 years. Like new month comes in, and I have to. We don't hear from him, and I have to text him. And eventually, he makes payment, and usually it's at the end of the month. So
Is
it's
this a
like
house or an apartment?
it's an apartment condo.
Okay, and this property was built before 1979?
Ah, ooh, good
In other words,
question.
are you under the rent stabilization ordinance?
Again, yeah, I
Okay.
don't.
Do you pay a yearly fee? Do you remember doing that?
No, no.
Okay, so your building's probably built after 1979, so you're under JCO. You are going to have to register that unit. But tell me, how many bedrooms does this tenant have?
Two.
Okay, so how much is his rent per month?
Um, we increased it to cover the utilities because utilities are separate and he's very sloppy. So we decided to do it 2,800 because before it was 2,500, but then we had problems with the meter net, different
Okay,
like.
well, you're above the threshold that I was talking about because the threshold for a two-bedroom is 2625. So assuming that's a lawful rent increase, and I kind of have my doubts, but assuming it is, if a tenant's not paying you the rent and you just don't want to deal with this anymore, it's simple. We can serve a 3-day notice to pay the rent. He's got 3 days to pay. We could serve it towards the beginning of the month. So if you've already gotten your rent for the month of March, and by the way, have you gotten your rent for the month of March?
No,
Okay, so we
because
can serve a 3-day notice right now. If he doesn't pay within the 3 days, we can evict your tenants. You can get somebody else in there. You can, of course, raise the rent to whatever you like once these tenants vacate, and you don't have to sit there and chase your money every month.
we'll make the mistake. We served them 60-day notice and like construct this notice from ChatGPT. I don't know. It's probably full of
Yeah,
mistakes.
I can tell you categorically that's not a proper notice to serve, but you got a great one. It's a notice to pay rent or quit. You might want to call the office and we can assist you with that, but you don't have to put up with tenants who are constantly paying their rent late. And we are going to move on to Allie. How are you?
Hi, can you hear me?
Perfectly.
How are you? Just a quick question. I have a 4-unit City of LA RSO. One of the tenants that I inherited, a very old lady with her son. She's the only one on the contract. She may be going to an assisted living. That's a maybe. If she does, am I obligated to continue with the son if he wants to stay, or his name is not on the contract? So, or does he have any justifications to say I need to stay because I've been here
And
for
again, what city is this?
Los Angeles?
Okay, and this building is under RSO?
Yes, it is.
Okay, and the son moved in with his mother?
Yes. Before I
Okay,
purchased it, they were there. Yes.
so in other words, when the mother moved in, she moved in logically with the son. The son is
Right.
now an adult, correct?
Right. Right.
Okay, so the son has just as much tenant protection as the mother. So if the mother moves out, you still have to deal with him.
Okay. So he cannot be kicked out of the contract. Or okay.
No, unfortunately. If
All
he
right.
had moved in after his mother moved in, now we're talking. Now we could raise the rent to whatever we like or ask him to move when the mother moved out.
Okay. Thank you. See you at the $1 million show.
Yes. What he was talking to is that I am doing there's a trade show for apartment house owners sponsored by the Apartment Owners Association. I'll be talking that in weeks to come, but it will be at the Los Angeles Convention Center, and I will be speaking, one of the keynote speakers, at 3:15, I believe my time is in the afternoon. Again, that's at the LA Convention Center, and that is set for April 16th. Let's move on to Mike Dirian. Say hello. Are you there, Mike?
Okay. Yes. Hi, this is Rena again. I just have a follow-up question on that property triplex in Glendale
Yes.
with the extra person in there. I gave my tenant a new application, and he completed that with her name, and I have her a copy of her ID. Should I do a new lease?
I don't think there's any reason to do a new lease, but it certainly doesn't hurt. So now you're basically approving them. So if the tenant has good credit, then there's nothing preventing you from doing another rental agreement. You might also want to check with the city of Glendale to see if they have any additional provisions for asking for more rent if another person moves in. I'm not aware of it, but there's so many jurisdictions as we saw from that chart that I posted. So I would definitely check that out. And we are going to move on to Eric Chavez. Say hello.
Hey, Dennis. So, hey, Dennis, I got three questions regarding language in the residential lease agreements, particularly the one, the AOA is the one I typically use because all the properties I have are under the RSO in the city of Los Angeles. So the first one is regarding the having landlord tenant waive the jury trial. I see you have that in your lease agreement, but it's not in the AOA. Why?
It's not an A. First of all, I help author and approve the AOA
Yeah.
lease as well. Uh, Under California's Constitution, a person cannot waive their right to a jury trial. So on that basis, AOA decided that they didn't want to put it into their lease. I put it in my lease for the small issue that I'm hoping it would dissuade a tenant from asking for a jury trial if he read that in his lease. That's the only reason why. But can I enforce that provision of the lease? And the answer is no. What's the next one?
Okay. The next one is about the security deposit. Um, is it? And I'm just going to say, can't we just put in regarding this interest on the deposit? The deposit shall be held in a non-bearing interest account, so we could avoid paying the interest on
No, the
this.
code, I was thinking that too. And I was thinking like, hey, I get a security deposit. You know what I do? I cash the check and I put it in a box on my desk and it bears no interest. But the city council in their regulations specifically state that if you get no interest, then you have to pay what our prevailing rate that we published.
Got it. Okay, and the last question is, I'm taking over new buildings, and so when it comes to, am I allowed to have all the tenants sign new lease agreements? They're all on a month, but I'm getting a lot of, pretty much no cooperation. They don't want to sign a new lease agreement.
Okay, first of all, you can certainly send to these tenants when you're now the new management or the new owner a rental agreement to sign. But unfortunately, as you're getting the pushback, there is no obligation on the part of any tenant to sign that. Now, you might want to try to do some incentive and say, you know what, if you do sign my rental agreement, I will forego a rent increase for 1 year. That might be some incentive. Otherwise, you're going to get hit with a rent increase.
So just so I understand this, so if the tenant just holds a position, hey, Eric, F you, I'm not signing that lease agreement. I have the one, I know my rights, I'm going to report you to housing. There's nothing I can do. It's just,
There's nothing you can do. They can't report you to housing. You haven't done anything wrong by asking. But again, there's nothing that you can do with that. And let's take a look. Uh, we're going to probably go with Harold Rhodes. I think I know you. Have I ever seen you before?
You look familiar, Dennis. I think you're an attorney, right?
Yeah, I think so. Let me check
Think-
my bar license.
I was wondering you were talking at the very beginning that all the landlords have to register with the city, but I thought you said they have to send you a letter first. If they don't send you the letter, you still have to register with the city.
No, they have to send you a statement with a statement number because you can't register unless you have the statement number. So if they haven't sent that to you, then I would just sit back. Again, they're only, even for single family homes, they're only sending that letter to you if the address of the single family home differs from the mailing address on the deed. Then they assume that you're not living there. They assume that you're renting it. So you do have to register, and you might register by paying the fee because it is registered, it is rented, or by filing that exemption.
Two quick questions. If you register, do you have to notify your tenant about that you registered?
Absolutely, because you're going to get a registration certificate, and that's supposed to be sent to the tenant.
Last question, real quick. If I had to go through litigation with my tenant and I never registered, can I just register the day before I try to do litigation?
And the answer is no, because you can't serve a notice, a termination notice, unless the unit is registered. So if you register it after, you're dead.
No, I'm saying it right before. Like, say I want to sue this guy next
Oh,
month.
yeah, then before you serve any kind of a notice, register the unit, then serve the notice, then you're fine.
Go.
Thank you. He said, go Lakers. Man, my team's not doing so good. We're all banged up. We got 30 seconds left, so we're going to go last time to Dana. Say hello.
Oh, hi, Dennis. I'm sorry. It's a follow-up to my question earlier. So if the seller tells me that they're not aware that those two tenants have pets, can I have them sign a pet agreement, and can I charge pet rent?
The answer is there is no such thing as pet rent or a pet deposit. That doesn't exist under the law. So you can have them sign pet rules that that the pets have to be on a leash and that you have to clean up after them and there can be no barking. But other than that, there's no way to extract additional fees from them. Anyway, thank you very much. We're going to end it here. I appreciate everybody coming out today, Saturday. You know we'll be doing this next Saturday. If you are listening to me on YouTube, I would ask that you please hit the like button and subscribe to my channel because it really does help. And I'm going to end this show with that song. If you're on the if you're listening to the edited version and you're not listening to live, check back and you'll be able to hear that song, Tenant from Hell #2. Thank you, everybody.
I'd find peace in my own little place, but now there's a storm, a tenant's disgrace. Late night knocks and shouting at the door. I never signed up for this kind of war. Leaky pipes and things that don't work right. The rent's a month late every single night. They've got a dog that barks like a beast, and I just want this chaos to cease. Oh, this tenant's got me on the edge of my seat. I'm the landlord, but it's them who's in control of this beat. I'm haunted by the sound of their footsteps in the hall, and every time I knock, they just build up the wall. I'm terrorized, oh, I'm terrorized. Landlord's life, now it's demonized. Painted the walls without asking my name. Replaced the locks like it's all just a game. Every complaint turns into a fight. I just wanted a peaceful life at night. There's garbage piled up outside the door. The utilities don't work anymore. I beg them, but they laugh and they say, you'll never get me out, I'm here to stay. Oh, this tenant's got me on the edge of my seat. I'm the landlord, but it's them who's in control of this beat. I'm haunted by the sound of their footsteps in the hall, and every time I knock, they just build up the wall. I'm terrorized, oh, I'm terrorized. Landlord's life, now it's demonized. I tried to get a court date, but I'm stuck in the maze of legal loopholes and endless delays. They know the system, they know the game, and I'm just the one who's getting the blame. Once this tenant's got me on the edge of my seat. I'm the landlord, but it's them who's in control of this beat. I'm haunted by the sound of their footsteps in the hall, and every time I knock, they just build up the wall. I'm terrorized,